Amelia Fletcher, very warm welcome to the Digital Markets Research Hub. I'm very grateful for the opportunity to discuss with you the latest development in regulation of competition in digital markets. People know you as a prominent academic, as a non-executive director of the Competition and Markets Authority, as a co-author of Furman Report, as a great musician, but among other these incarnations, I also admire your ability as an economist, but when policymaker, to understand legal, purely juristic mechanic. I will always remember the panel which you had with few other female prominent academics and policymakers, where you have somehow discussed the Digital Markets Act in such detailed nuances before most of us were able to understand it. Obviously, the big temptation to look at the Digital Markets Competition and Consumers Bill, but it will be quite a futile endeavor because it's in the parliament, and obviously we'll talk about it, but not about purely juristic nitty-gritties, or maybe addressing only some of them. But I propose starting with this Furman report, this kind of the milestone, which somehow identified together with Philip Marston, with Diana Cole, and some other co-writers. You have somehow made a snapshot of what is going on, where the systemic problems are. 5 years is kind of usually a revision period. It's still an ongoing endeavor and looks like a never-ending story to some. Where are you from your perspective in terms of the process, in terms of the destination?
So, thank you. And I should just say, yes, I'm on the board of the CMA, but whenever I speak publicly, I'm not necessarily saying the views of the CMA. These are very much, anything I say will be probably my own views, but certainly not theirs. In terms of the Furman Report, which, as you said, came out in 2019, so a while ago now, actually, I think for the most part, at least none of the authors that I've spoken to recently about it feel very differently. I think we think that our diagnosis at that time still holds. I think we might have been a bit crisper about how we expressed it these days, but I think basically our diagnosis that there was a small number of very entrenched digital gatekeeper platforms that where there were really both intrinsic economic reasons why those markets had concentrated and why there was significant market power, and there was evidence of anti-competitors as well, and some history of anti-competitive mergers. All of that combined to create a situation where ex-ante pro-competition regulation was needed, and I think that none of us have changed our mind on that. I think we might have been, we were hopeful that action would occur relatively soon, but our focus, of course, was in the UK. I think we were surprised, or we would have been surprised, at quite fast action elsewhere, and in particular in the EU. And of course, I think our diagnosis was, I think it was pretty influential in the EU, but the EU didn't take quite the approach to regulation that we had recommended, in that it wasn't as kind of participative and as bespoke as we had proposed. Now, therefore, and the UK DMCC law that's coming through is more like what we proposed. I think a really interesting is actually which of those two approaches will be best. I'm inclined to think they're not actually as different as might suggest that they are, because actually I think within the EU approach, even though rules are in the legislation, I think there's quite a lot of debate to be had about exactly the application of those rules in a way that will be more participative. Equally, in the UK, a lot left to the CMA in terms of imposing precise rules. So the legislation seeks to provide categories within which rules can be imposed, but not to specify the rules. Nonetheless, I would envisage, and past work by the CMA in its market studies into digital platforms, digital advertising, and also into mobile ecosystems, suggests that the CMA is not imposing rules that are hugely different to those that the EU has imposed. And there will obviously be areas of, not obviously, but there may well be areas of difference. So, for example, I imagine it will take a more bespoke approach and not impose rules which the EU is kind of required to, but where that might not be necessarily the most sensible, most sensible thing. But I would envisage that really the difference in practice will be much, in terms of the rules applied and probably in terms of the whole procedure, will be much less different than it might appear on the tin.
I'm sure we will have an opportunity to revert to some procedural differences. I think the drafters of the bill have used this second move advantage to learn from the DMA, the purely legal mechanics, and to somehow to adjust the draft to what is in the interest of the UK economy, society, and competitive markets. Now the question is, obviously, whatever regime we take, EU or UK, we see that the enforcers or the compliance monitors, as some would expect them to become, would be granted with wider discretion in order to pursue something which is much more ambitious, probably much more difficult to define, as we knew from the past, in terms of the goals of competition law, economics, and policy. So what should be these goals of digital competition policy, let's say, from your point of view?
Well, I mean, I think the absolute goal of what both the EU and the UK are seeking to do here is to create an environment in which we see lots of innovation that is beneficial to consumers and businesses. But in the process of doing that, ensuring that it's an open market for that innovation. So disruptive third-party innovators are in just as good a position to innovate as the incumbents that have entrenched market positions or have historically had market positions. And I think that was a big concern in the Furman review, that actually the playing field was so tipped against those third-party disruptors that essentially the only innovation that we would see would be from the incumbents, and actually their incentive to innovate would be more limited because they weren't facing, this risk of disruptive innovation. So really, I think that's the overall aim, or at least I feel it should be the overall. I think the problem with innovation as a kind of formal legal objective is you can have huge debates about what's the best thing for innovation, and actually it might not provide the clearest guidance. So what we took the view in the Furman report, and I think is the correct view, is that in almost all circumstances, at least where you're at the kind of end of the spectrum where your problem is market power, actually more competition will be good for innovation, and a more level playing field will be good for innovation. And that's a much easier thing to target regulation on. So we propose that the regulation be targeted with the objective of competition, but in the minds was, competition is great, but here it's particularly great because it's good for innovation. In the EU, they've clearly gone a slightly different route in that they introduced fairness alongside contestability as the objectives. But I read fairness as partly being about preventing current entrenched positions being exploited unfairly, but also about not those current positions to leverage into new markets. And that is actually all about competition as well. So, I mean, it's called fairness, but I think there's a big contestability angle of fairness within the DMA. And in fact, in the UK, Furman report was mainly focused on competition, but as you'll be aware, the digital advertising study set out 3 objectives that they thought was appropriate for the UK legislation, which was just about about competition. And those three objectives that were identified then, which includes transparency, includes fair choices, those have made their way actually into the final legislation. So that was something that was added within that study rather than by the Furman Report, but I think actually is relatively well aligned with where the EU ended up as well.
I want to stick for a little bit with this goals questions and maybe project it to this dimension. Obviously, greater discretion envisages, and you cannot find the answers in the textbooks or with proper calculus. These answers are not discoverable because they coexist simultaneously. Whatever option, reasonable, prudent option you select, it can be considered as a legitimate, pro-competitive option. So it's not singular. And obviously, it begs the question: what would be their relationship with other regulators of digital economy and digital society within Digital Regulation Cooperation Forum, of course, and maybe also vertically with the government, if this broader mandate is not empowered by the kind of single metrics price theory, but you have discretion, obviously, and also in terms of how you designate, how you tailor mandatory requirements. It's even broader than Article 6, where it's the obligations are susceptible to being further specified. You can design, the CMA can design obligations which aim to achieve the goals in Section 12. So the discretion is with the enforcer. Do you expect some more institutional communication with the government and sectoral regulators?
I'm not close to what the CMA is planning in that regard, but I would think that the CMA, by its nature, in terms of trying to create an environment of participative regulation, would be speaking to government, would be speaking to other regulators, also would be speaking to the regulated firms, the SS firms, and would be to third-party end users or representatives of end users and representatives of business users, and maybe some big business users as well. So I would think they would be listening to everybody and thinking about what those rules would be. Clearly, there's quite a complex environment in digital vis-a-vis other regulators, because there are issues in digital that other regulators within the UK have run. For example, the most being the online harms work at Ofcom, but also the FCA has quite a focus on fintech and elements relevant to financial services more generally. So, I think in history, the CMA has always liaised well issues with other regulators. We now have, as you say, the Digital Regulation Cooperation Forum to really facilitate that. Obviously, a particular new which is a space that the CMA hasn't tended to liaise as much, is the ICO, Commissioner's Office, because of the importance of data in digital markets and therefore all of the issues around data protection, and the recognition that actually data protection and competition can absolutely stand side by side as combined objectives, but occasionally there can be tensions as well. And really being in a position with a good relationship between those two regulators to both maximize these, but also find ways through the tensions is going to be really, really important, and has already been really, really important.
And we see very recently examples of your cooperation with SEO in terms of Privacy Sandbox initiative, investigation, as well as on the European level, the meta judgment, another kind of emblematic example of where we move in at least. Okay, so sticking with this regulatory dialogue, I also remember you when these ideas were only somehow at the level of reports and broad academic discussions, you were very enthusiastic, trying to emphasize that we shouldn't be overly excited about increasing fines to the just for their own sake, that it's less about fining, it's more about regulatory dialogue. So you might need this kind of tool available for just in order to stress the power that you are serious, but it's not about imposing highest fines for their own sake. I think other commentators also talk that not about enforcement, but about compliance. So what is your position? Do you still consider it as one of the important features of the new modality?
I'm in the same position. I think that the regulation should be a positive, forward-looking process that is designed not to penalize people for bad behavior, but to actually say, let's work together to work out how we solve the competition problems that have emerged in this market that may not be fault and maybe people's fault, but let's not distinguish. So let's do that. And so I'm very focused on that forward-looking. However, I have to recognize that the incentives of the parties to do that forward-looking work may need the kind of the threat, the stick of enforcement. So my perfect regulatory world would involve zero enforcement, because the stick of enforcement is efficient to encourage everyone to engage and actually move forward in a constructive way. I recognize that that's a naive view and that we may end up with real enforcement, but hopefully the balance of what the regulators end up doing will be less on the enforcement and on the proactive, pro-competitive engagement. But we'll have to see. A lot will come down, I'm afraid, to the reactions of the regulated firms.
And where would you expect this dialogue being the most productive? At the level when you tailor obligations or conduct requirements, when we talk about let's say fairness related obligations, or at the level when the undertaking the strategic market status will bring the contravention benefits exemption, plea for the exemptions, or maybe at the level of commitments, where this dialogue appears, we don't know, but appears to be the most efficient.
I mean, I think it has to be most efficient upfront, setting the rules, setting the framework, because the whole idea is to set a clear framework, which then the gatekeepers or SM platforms function within, and then end users know what to expect, business users know what to expect, and potential roles know what to expect, and they can therefore know how to innovate and compete within a framework that is set. So I think the more that can be done, the better. Obviously, again, there's a kind of naivety issue there, which is we know that actually we're not going to get everything right up front. And there's going to be these debates at a later stage in relation to commitments, in relation to enforcement, and therefore the customer benefits exception. The same will be true, actually, I think, in the EU, despite the apparently greater clarity of those within the law. I think there will still be a lot of debate about what exactly they mean. So I think that, you know, hopefully we can keep as much of the clarity up front and have relatively small things that we're debating on an ongoing basis. I really hope that's the case, and we don't end up kind of debating the big things on an ongoing basis, because that won't provide that clarity of guardrails framework that we're really seeing here.
And in this regard, probably Section 5 appears to be not particularly exciting in terms of designation, where you would expect to demonstrate 5 years forward-looking projection about the future. But the dialogue also envisages an important communication with undertaken with strategic market status, but obviously third parties as well. We remember how vigilant the Commission was trying to minimize the scope for mandatory communication with third party, obviously or probably anticipating the avalanche of real potential and hypothetical submissions from thousands, and we know that they must have thousands of business users. So it's not, the Commission managed to somehow to defend itself from potential spamming. Some people use this word even in academic literature, actually. What is the position of the CMA? You are required to be more open. I think public consultations are there. What is the role of public consultations? How seriously they are being taken? Do you have to systematize? And what is the outcomes of the model which is being envisaged in the UK?
The CMA has always done a lot of consultation, in particular in the context of market studies and market investigations. Which obviously the EU doesn't do. So in the UK, the market studies and market investigations tend to set out kind of issues papers and a variety of steps at which views are invited, and then the CMA gets a huge amount of very often of submissions. Now, I mean, this may be a step up. We may be going into a world where we're going to get even more submissions, in which case, think about how to deal with that. I would note that the CMA, when at the start of COVID, there were very serious concerns by consumers about a variety of areas of profiteering, from kind of face masks to toilet paper to etc. And the CMA wanted to try and understand the extent of those concerns, and therefore actually set up a new complaints line or a form which enabled very large numbers of people to feed in their views in a formalized way that could be analysed easily by the CMA without investing in kind of thousands more staff. So the CMA experience of that, if it needs to do something like that, if we're really talking, hundreds of thousands of people submitting, but I think if we're talking hundreds of people submitting, the CMA has plenty of that experience.
And okay, so we have covered different geometries with regulatory dialogue. I wanted to revert to more substantive issues of theory of harm. You publish extensively on these issues, and in particular, I think you have articulated some very interesting ideas about choice architecture and how these issues are expected to be with us all the time, pretty much. Is it even avoidable, particularly with all these large language models where the controllers of the models, they can somehow instruct the model to design the choice architecture in a way which would be somehow unbeatable, A, and B, also, I think some people say how diligent the choice architecture are with experimenting with thousands different models and testing it on myriad of different scenarios and formulas. Is it even possible to avoid, to minimize, to learn? What is the outcome of your research on this crucial topic?
So yes, I think that choice architecture, which I would note the CMA published a really, really good report on last year, not in the context of digital regulation particularly, but more specifically just in the context of competition and consumer policy. But I think choice architecture is being increasingly well understood as incredibly important for the choices that people make online, and in particular end users make online, and that yes, firms are in a very good position to experiment, to create choice architectures that essentially lead consumers, end users in the ways that they want, that are desirable to them, may not necessarily be so desirable for either the end users or for competition. Now, actually, choice architecture is a neutral term. It's unavoidable, and a lot of what firms do in terms of choice architecture is actually hugely positive. You can't let consumers choose everything. For example, if I haven't got I often have a mobile phone right by me that I can, here we are, in a mobile phone, there's been so many design choices. I don't want Apple to ask me my views on all of those millions of design choices. I have no ability, I have no clue. But there are certain design choices where actually they can have a really big impact on competition or contestability, and where actually I might have a view, and actually therefore where if they steer me in a particular way, that can have an anti-competitive effect, whereas a different form of steering could have a pro-competitive effect. And so I think that what the EU DMA has done is quite carefully think through where are the key areas where we think that steering could be having an anti-competitive effect and could have a more competitive effect, and therefore where we should be putting in rules to try and make sure that that occurs. And so there are specific rules in 6.3 and 6.4 about making it easier to have to change your default settings, or to download third-party apps and then make them defaults as well. There's the requirements to have ask consumers, end users, to make positive choices as regards some key areas, so browsers, voice assistants, and search engines, to really try and overcome the natural tendencies of users to go with the status quo, to go with the default, but actually encourage them to, think more carefully about these decisions. Likewise, all of the provision in the DMA on self-preferencing, 6.5, I think is really interesting, because they didn't go for a standard kind of complete prohibition on self-preferencing, which actually is what the equivalent US regulation seems to impose. They simply went, and it's not simple, there's lots of complexity, but they much more narrowly went for a restriction on self-preferencing in ranking. And I think that really reflects the recognition that ranking is one of those parts of choice architecture that can have a really big effect on people's decisions. And people are much more likely to choose something at the top of a list than they are even the second or third or fourth on a list. And therefore, where you rank things, how you rank things, the sort of information you provide can all have very big impacts on consumers' decisions and therefore on competition. So I think the EU DMA has been quite forward thinking in terms of its introduction of kind of behavioral insights. I've recently written, I literally published a draft yesterday on some looking in a bit more granularly at some of the provisions and some of the behavioral insights that might be relevant, and in particular, some of the ways in which a gatekeeper who wished to could try and circumvent the provisions, and by kind of essentially designing their choice architecture in particular ways. And therefore, those are things for the Commission to look out for to ensure that they avoid circumvention. So I think this is a really interesting and big area that obviously the CMA, other than its choice architecture report, hasn't said anything formally about this in respect of the DMCC, but I would note that actually there's quite a lot in both the digital advertising market study and the mobile ecosystem market study, which is essentially about choice architecture. For example, in the digital advertising market study, there's lots about the choice architecture around privacy consents and how much are consumers, end users steered into just accepting whatever privacy terms the gatekeeper SMS firm wants them to accept, rather than thinking actively about that question. And in mobile ecosystems, there is a discussion of people's tendency to just use the default browser, the default game store, even when they have a choice.
Do you see sufficient level of awareness of potential new entrants, about the opportunities which the new regulatory models create for them, or is it something which we somehow create? Our task is just to create the structure, the rules, the opportunity, the doors, and rather than bring them and say try to compete, try to outperform. How do you see this kind of KPIs in terms of the most ambitious horizontal dimension, least plausible and easiest to ridicule, so to say, that we don't want to create our Google, we cannot, but it's still something on the list, or it's something which we just create and then say, okay, that is for you to do it?
So I think to some extent that's what you have to do as a regulator. I mean, you create the framework and ecosystem within which innovation can happen. You can try and make it more known that that's what you've created, and be as clear as possible about what the rules are, so it's not incredibly hard for third parties to try and work out what the rules are. But thereafter, I think that's, you can't actually make innovation happen. You can't make these people come into the market. You might want to, if you don't see it happening, you might want to question why not. I don't think that necessarily means the regulation has failed, but it raises questions that you might want to think about. That said, I think that actually in quite a lot of these areas, there are third parties out there who are pretty well aware of what's going on. Actually, in some cases, the major gatekeepers themselves might be competitors to each other. And so they're definitely aware of what's going on. But even some of the third parties, the kind of Mozillas, DuckDuckGos of this world, they're very clued up as far as I can tell. So I think, you know, there may be some way to go in terms of ensuring that third parties really understand what's happened here or happening here. But I think that a lot has already happened.
You said that you said it yourself. Ecosystems, we have new buzzwords in the town, and to my surprise, the most skillful minds and the most pioneering minds are now talking about the mechanics of ecosystem as if they compete with each other. Should it be like in the way of professional league in the North America, where you have 8 players? No promotion relegation system, but it generates excitement. It generates all the values formally acknowledged as kind of pro-competition. Or should we somehow try to nurture the model where formally it's as or even more appealing in terms of revenues generating and audience attraction, but still containing some elements, allowing clubs from smaller cities and towns to promote to the top league, and then.
Yeah, I mean, I guess I prefer the UK football system where football teams have the ability to get promoted and get demoted. It seems to create a lot of competition and maybe a bit of innovation as well. So I don't know how far the sports analogy really gets you, but I do worry that, yes, the major ecosystems can enter into each other's markets, and they have in the past. But there has also been a degree, I believe, and not sufficient that one could ever bring a competition case, I doubt, but there's been a degree of live and let live. So, oh, well, they're big in that, I'm not even going to try and compete with them there. They're really big in that, I'm not going to try and compete with them there. Now, there are obvious examples where that's not the case. Microsoft has really tried with Bing to compete against Google search, for example, and clearly Google, Android, and Apple are, competing in mobile ecosystems. So we see a degree of competition between them, but personally, I think that's never going to be sufficient. That's positive. And the more we can build it, that's great. But that's never going to be sufficient. We really, really need the ability of third-party disruptors to come in as well. And that in turn might actually help drive innovation by those incumbents, but also bring in new ideas and new innovations.
And when we talk about remedies, obviously we mentioned fine that just this accelerated hype about and remember there was in the DMA a mandatory proposal of mandatory 4% minimum fine. We have other remedies, more nuanced, and some are even more draconian. For example, structural remedies. Are you in favor? Do you think we can engage in these very risky activities in what circumstances, or should we do it at the merger control level before, rather than expose? So once this happened, what's your view on this?
So, I mean, personally, I think it is better to address these sorts of things through merger control if you can, and that's because it's always harder to unscramble eggs, as it were, and there will have been a lot of investment in that process that may be wasted. So actually, if you can use merger control, that's good, and I think we have been a little too willing to stand back in some of these mergers historically, out of a general belief that this was such a dynamic market, there couldn't possibly be any competition harm, and I think we were naive on that front. I think that has now completely changed. I think that all of the competition authorities around the world are making they're at the very least being more curious and asking questions and being a bit more skeptical, in the way that I think they always should have been, and they are actually in other sectors already. But I think that's now they're now being more forceful in that area, and they're also being more thoughtful about potential competition and dynamic competition as potential theories of harm, which are hard to evidence. They're hard cases to bring, but I think that in the end, it's really important that there can be really serious harm arising from those theories of harm, and therefore it's really important that authorities take them very seriously and that courts support them in that. However, I also think that you're always going to get issues that are of a structural nature, even if you've done your merger assessment, as well as you can, because you're always taking a prospective, forward-looking view in merger assessment, and there is actually a risk of being too cautious. So you've got to kind of you can't be too cautious, and that means that there will be some mergers that end up creating, anti-competitive harm, but are let through because the evidence is not sufficient at the time of the merger. Therefore, I think it is appropriate to have the ability to have structural divestments. That said, I think they do need to be considered with extreme caution. And I do think there are going to be issues of proportionality if kind of the UK or the EU individually are thinking about divestment, because actually trying to work out how to divest something just in the UK or just in the EU is far from straightforward. So you're probably then talking about a divestment, in some cases at least, globally. You've got to think about what that means in terms of proportionality. So how often this would actually be used, I think, is a very open question, but I do think it is useful to have the power. In the UK, in market investigation references, we've had the power for some time. It's been used very sparingly, but it has been used. And in fact, most of the times it has been used, it has proven to be a really positive thing. So for example, it was used in the context of airports, where we had a lot of local concentration, and we required can't remember if it was the CMA or its predecessor, the Competition Commission, but they required divestment. And actually, I think most people would consider that had been a good decision. So yeah, so I think it's good to have the power. I would note, of course, that the US is also now considering the potential for structural divestment in the case of the Google ad tech chain. So, I think what would be ideal would probably be for the biggest relevant jurisdictions to all reach a similar conclusion. So that, a bit like in mergers, you could do something in a coordinated, as coordinated as possible and as legal way, but we will have to see.
And if you look at this stakeholder workshops on the DMA, we hear every time the Commission stressing that DMA is not a continuation of competition policy. It's a new start. It has the competition pedigree, same people, same intellectual matrix, so to say. But procedurally, we want to start from scratch, maybe protecting ourselves against these procedural pitfalls which we inherited from ex post enforcement, where a micro mistake is being accelerated by the most skillful super heavyweight players of legal and economic profession, and trying to leading often or occasionally to really bad outcomes. So that would be one of the explanations. We see that the DMCC positions itself as a kind of continuation of competition law. Do you think that we will be, it's obviously a crystal ball question, we will be impacted positively, negatively, or maybe not by the legacy which we already have in the current jurisprudence, case law, and also in intellectual models of ex post enforcement? Or will we have an opportunity to start from scratch and to generate our own mistakes in the digital sphere?
So I think absolutely the idea is it's a whole new in both the EU and the UK, it's a whole new regulatory regime. The concepts are different. The procedures are different. So everything should be different. And I think it's an intentional, in both jurisdictions, actually, an intentional move away from the competition law environment. Now, it is clear that the EU decided that it couldn't be called competition law, but I think that's partly for legal and political reasons. I think everyone in practice sees it is a kind of form of competition law, and contestability as a concept, which I actually like because it captures, I think, competition in the market, but also competition for the market. So I think it's a good word, but I think it was primarily chosen just to have a word that wasn't competition. Obviously, in the UK, we didn't have that kind of political constraints, so we've been more relaxed, and we have also maybe brought in a little bit more from competition law, in that we do have to show market power, whereas in the EU, the requirement is only to show a strong and entrenched market position. So that is somewhat different and a little bit more aligned with competition law, but still it's not a dominant position. It's clearly a determination to make have a different test, so it's not held to all of that former jurisprudence. And there's a little bit more focus in general on thinking about harm and the bespoke need for regulation, as opposed to in the EU, where the idea is that these rules were put in place in legislation based on a huge and extant knowledge and economic literature, but once they're there, as it were. But I think that, so I'm not answering the question terribly clearly, but I think that having done that, competition law is still there. It's still a wonderful complement, and I would expect both the EU and the UK to continue using it. But I do think that these regulations will hopefully really better enable the things that they're trying to enable, which is speed of action, easier administrability, easier enforceability, and just greater clarity of what is and what is not allowed, both for the firms themselves, who should appreciate that, but also, as I say, for the potential disruptive and innovative rivals, so they know what they're kind of playing against.
Excellent. And maybe the last question on the role of private enforcement in this model. We know that in the ex post vision, the more we enforce, the more we identify instances of abuse of dominance and combat it, the better it is for market, or we can accept it as a stylized option. Here, when we talk about conduct, and you mentioned it yourself, I think, so it's no fault conduct. Yeah, essentially, it's most of the instances are absolutely okay. So there are some punitive elements, this asymmetric, because we want to somehow to limit the omnipotence and omnipresence of some for the benefits which we have highlighted. But still, so the fruits are designed in order to enable the enforcers with this significant proactive competences. The fruit is designed to be in low hanged for public enforcer. We now see many instances of third-party funded litigation, or not necessarily, maybe just very mindful of their interests, private parties, collective consumer collective redress, who would try to use this opportunity as well, and thus somehow mitigating this stick, the power of the stick which is hanging on the wall, which is not being used for right reasons, probably strategic reasons by the public enforcer, and will be using them for their own benefits, which is, on one hand, many would say, well, that's how competition is. On the other hand, it would be done, it is kind of zero-sum game in some sense. Is it, or it's too somehow esoteric to envisage these models?
So on the one hand, I think that the fact that the firms have not necessarily behaved badly in the past doesn't mean that if they then breach a regulatory rule going forward, that they're not now behaving badly. And so there's a little bit of me that thinks that the public enforcers have limited resources, and therefore if there are breaches of the rules, then actually allowing private enforcement to support the work of the public enforcers is actually quite positive in helping this whole environment and regulatory ecosystem to function effectively. So that's the kind of positive argument, and I do buy that to some extent. I also, however, do have some nervousness, because I do think that there will be areas where actually the whole point of regulation in a way is to have this regulatory dialogue and to work out where the blurry lines are, to actually have an open debate between the regulator and the firm about what makes most sense from a competition perspective, from a user perspective. And I slightly worry that the spectre of private enforcement might make that regulatory dialogue less open. And so I personally, on balance, if I'd have been designing this system, and I'm an economist, not a lawyer, would probably have not had private enforcement as part of it, because I do worry that it's going to make that positive engagement between regulator and regulated. And also, as you say, the ability of the regulator sometimes to turn a blind eye if they realize the regulation is actually going to do more harm than good, which it can. So I think that is actually quite a positive thing. I think all of that will be made so much more difficult by the threat of private enforcement, that on balance, I wouldn't have gone where they've gone in both the EU and the UK, but I understand the positive arguments. And I also understand that legally, or at least I have been told that legally it was hard to design these systems without allowing for private enforcement. So it's just a constraint that we have to work under.
As well, I think as it was legally difficult to design a system without this mandatory public consultations as well. I think somebody in one of the previous panels mentioned it, that there is little choice on this. Amelia, we have this tradition to end conversation with recommendations recommendations to students, purely professional or maybe something broader? What would be yours?
Yeah, so I mean, I guess it kind of depends if they're a student of economics or law. But what I would say is what I love about competition policy generally is that it involves this combination of law and economics, and that they build upon each other in a really interesting way. And actually, some of the biggest developments in economics in this space, in our industrial organization, have actually come through legal cases. So, which has been really interesting, but actually it's really interesting to see how the law has changed over time to reflect economic learning. So I guess my suggestion is that any legal scholars should really do a bit of economics, IO economics, and any economics students that are doing IO should really do some law as well. I wish actually I'd done a bit more law back in the day, but my time in public enforcers has, I think, given me a reasonably good education by now. And then I think the only other thing is, you mentioned my music earlier. I've done music kind of since I was at college, and absolutely pretty much throughout, with a few little gaps. And so I don't think everybody should play music, obviously, but I do think there's something really positive about having something other than your day job that you really care about too. And that doesn't mean that you don't give your all to your day job, but it does mean that you've got this kind of little bit of extra resilience because there's something else you really care about. And that can just be your family, it can just be anything, but it can be rock climbing, running, whatever. But finding the time in your life to do that one other thing that you really care about is a really positive thing, I think.
I'm sure many of our listeners will interpret your last recommendations like, you do DMA, do a little bit of DSA or something.
Well, that too.
Amelia Fletcher, thank you very much for sharing your brilliant ideas with us.
Thank you very much for having me.